for delivery to order, Resolution 60/2026, Muhammad Manna Salih versus Union of India. In order to deal with your point raised, do a elaborate exercise. There are some 31 pages. Yeah. 2020, we are not adjourning any of the matters because there are all pending matters. Unless we take the records, we are not adjourning any matter. You'll have to wait. Whatever be the good reason, but we are not adjourning any old matters. What is the date of death? Intimate him about the legacy, and even that was not brought on record. So by the time, my lord, actually this appeal has abated, my lord. And if your lordship see the last order, there also we had submitted to the court. Just wait, then let us see the record. Yes, my lord. Yes. When the item reaches, my lord, we'll make the submission.
Item number 4, my lord. The sole respondent already died, my lord. My learned friend is here.
Well, on 7 February 2026, he has died.
7 February 26.
26. Yesterday, I have received information, then we intimated him.
Okay. Mr. A. Martin, counsel for the appellant submits that who has died?
The sole respondent Ismail
Shirazi. That the sole respondent has expired. Mr. N. Hawk, counsel for the respondent submits that he has also received instructions that the sole respondent has died on
7 February
7 February 2026. Accordingly, he prays for some time to take appropriate steps. So matters is adjourned today. This after 2 weeks.
In concern of the others, there are back to mention item number 12, When it will be fixed after 3 weeks,
Date may be fixed.
12,
Give a date after vacation. Item 12. Both sides are represented on the prayer made by Mr.
M. Das.
M. Das, counsel for the appellant.
Appellant.
Matters from adjourned today. List on. Motion.
Obliged.
Your lordship, my lord, item number 16, my lord. With consent of the other side, my lord, I beg to mention, my lord.
Item number
16, my lord, supplementary, my lord.
yes.
To those, my lord, maybe after vacation, my lord, I have some difficult.
No, this is 2019 matter. We are not adjourning.
My lord, really some difficulties, my lord. I could not appear, my lord.
2019 matter. We are not adjourning. We will only adjourn when we see the records. All pending matters we can't adjourn.
Obliged, my lord.
May I please, your lordship? I beg to mention item number 7, lordship, with the consent of other side.
7 is 2018. No, sorry.
Lordship, the learned counsel is in this.
Whatever be the good reason, we are not adjourning all matters. Yes.
Your lordship, I beg to mention on listing over
This thing is court master. Second court master. Yes, item 1.
Lordship, with regard to item number, even the supplementary release, first motion, Lordship. Supplementary release, Lordship. Item 15, Lordship.
Yes.
We have filed one written objection today itself, Lordship. That may be called for.
Copyright.
For orders, item 1, WPC 1754/15.
Mr. Mazumdar and Mr. Das. Yes, Doctor. As well as you, Mr. Nath. In this matter, I have to tell you something along with Registrar Judicial. Please come to the chamber. There is a. You can also please come. Yes. It's not to be said in the open court. As you know. You can come over and I'll give you. Instruction. Thank you, Lord.
itu আমার এই এমসি itu আমার ini foto দিবেন না
There was a judicial order which was passed in WPC 5229 of 2016. There we requested the registry to place that order before this bench. To explore the possibilities that the Home and Political B Department would create a portal accessible to the said department where the daily orders passed by the Foreigners Tribunal would be uploaded for internal assessment and monitoring of the functioning of the Foreigners Tribunal. We will give you this order.
Regarding the issue your lordship is just now. My grandfather has collected the instruction that I convey to your lordship.
In this, we have given the order, we have flagged that relevant fact. What has happened is
Yes.
witnesses were examined, they are cross-examined on their different dates, but those are not part of the orders. So therefore, if a witness is examined or cross-examined and they are not reflected in the orders, it takes away the credibility of the opinion itself. So therefore, what we wanted is that just like our High Court or the trial courts, they have a portal where they upload it.
Yes.
You may not keep those orders in the public domain, but at least the orders which are uploaded will be looked into by the department. This is required for two purposes. Number one, for your own monitoring of and the assessment of the presiding officers. If they do not follow the basic requirements of inform the litigants about the nature of evidence recorded. Just look at one or two paragraphs, you will come to know. Last paragraph. And Mr. Mazumdar,
Madam.
all this came to light because on that day I took the file home, and when we saw the records, this are coming out.
This has to be taken up.
You see, this is also required for your own monitoring
Madam.
because the law is very clear that the proceeding will give their evidence,
Madam.
and if required, the state will give rebuttal evidence. Now, how would the state know whether it is appropriate for the state to have a rebuttal case or rebuttal evidence if nobody is monitoring?
And this is from Kamrup.
Something serious, some serious problem is there with me.
No, it's not a serious problem. What happens is that since there is no monitoring, they become very casual.
But this is too casual.
Hmm?
This is too casual, Member.
That is why I have to
Well, that's
have this order in the monitoring.
exactly, Member. And the orders that your lordship has quoted, the reason for not passing the order is also
This is my part. Good, good monitoring. That's why we have to request this
serious
matter
monitoring.
to be listed in this.
In the
monitoring
last
line.
order also, para 4 lordships reflected this aspect of the matter.
You see, what happens is that if you create that mechanism, at least all the members of the foreigners tribunal will be cautious that their orders are being monitored at some place. And if officers, the presiding officers stay for a long period in one station, that is also perhaps not good. It is subject to your assessment.
Yes, yes.
It is given, no? So today what we have to say, the affidavit is not been filed.
Yes, my lordship, there is a written instruction there. I just.
Yes, we got it.
The motion is.
This we will be too happy to permit for the foreigners, Nalbari to vacate. You have seen this? 27 May 26.
Yes, more the additional. Yes.
Now the state government wants the tribunal to be vacated.
Notice on the side.
But then your home department will have to request, the procedure is that the home department will request the district commissioner to find a suitable alternate place.
Second page. That has already been, in this, today's instruction, second page, what we will find.
Okay.
This is an overall picture, but the thing is, this is urgently 27/9/2. It means I think.
What should be done, Mr.
This I think we will take up.
This? No, but you see, the next budget will be, we are anticipating that the voter account will be either last of this month or in the first week of July.
Lot will make some reference in today's order matter so that we can take up the matter. Because
No, because this, for the upcoming regular budget, we have already put it in the order dated 2/4/2026.
no, that is, I'm talking about this letter from the Jila Parishad.
No. It's also the relationship Makora and Makora. Alternative তাৰপিছত কৰাটো বেলেগ কথা। Madam.
And in fact, to some extent, it will depend on the person who inspects from the PWD. And he has to give an estimate what expenditure will. Condition of the toilet in the old building I have noticed, it is worsened. I'll tell you. Yeah, I'll take your call. Yeah, that's. We'll take up. They have asked for just some more time than they. MCD. Yeah. Stationary. I remember now I recollect. Some of them expressed that this is the problem where this. I was there. Which is. Also will give information for 10 days. If your lordship just goes to your lordship's last order, particularly paragraph 7, madam. In the last order passed on 2nd of April, madam. In paragraph 7, lordship indicated. Paragraph 7, madam. The court expects that on the next date of listing, a detailed affidavit be filed regarding the data that has been collected regarding available infrastructure and lacking of such infrastructure, and to indicate the steps taken for creating an appropriate courtroom for the constables. You know, to all the constables, district commissioners, and we are informed, but this report from all the district commissioners have not come till now. So sometime will be required, we'll file the affidavit. Some have already sent the report. The data may be lots of actually. It is not yet complete. Madam. Madam. Lordship will give us some time. In the meantime, Lordship may pass that order also. If in case we some of them fail, then we'll come up with the name of the districts from where the report will come. If they in the meantime furnish, then we'll in the affidavit will indicate. Madam. Madam. Now it is restored. We didn't know that.
The restoration is not the thing, Milord. The question is important, Milord. Hmm.
I didn't know. We'll
Hmm.
find out one.
No, okay. Look, one your lordship has already seen, my lord. There are two more letters. 19.5 and another is 18.5, my lord. One is with regard to, my lord, Foreigners Tribunal 2 Borpeta. Yes, my lord. This is same as repairing and maintenance.
My love. Five. When you go, it will get 25. Just now they have given this, we will take up on this one. Just now I have got this later. Lottery will give me around 3 weeks time in the meantime. If somebody, some district commissioner doesn't, will specifically indicate. Manner. 15 manner, 15 as your lottery was seen in the letter itself, they have been asked to identify that will take some time. Identify this in this letter, identify suitable government building within your district for shifting and accommodating. I will write all these things to this one. These things, I didn't know that this is the position.
Mr. The learned additional advocate general, assisted by the learned senior government advocate, has referred to paragraph 7 of the order dated 2/4/2026, and it is submitted that though the court expected that by the next date of listing, today, detailed affidavit regarding the data that has been collected regarding available infrastructure and lacking of such infrastructure, and steps taken for creating appropriate courtroom for foreigners tribunal. However, though the Home and Political (B) department has written to all the district commissioners, but the requisite information from few districts is still to arrive. We place for further 3 weeks time to collect the relevant data and to file an affidavit. Next paragraph. Review of the claim made by the additional advocate general, the time as sought for is granted. However, the Home and Political (B) department shall inform the court about to disclose the names of the districts of which the district commissioner has not provided the relevant data, so that the court may pass appropriate orders on the next date for their personal appearance with all the relevant records relating to the infrastructure of the foreigners tribunals. Next paragraph. We request the learned senior government advocate to transmit the copy of this order to the Home and Political (B) department to take up further action and to file an affidavit on the next date of listing. Next paragraph. Mr. H.K. Das, learned senior counsel, assisted by Mr. M.K. Sharma, learned counsel, has produced a copy of letter dated 5/5/2026 by the former member of Foreigners Tribunal number 5, Morigaon, indicating that he had superannuated from service in February 2026. So, however, his area bills, including petrol, oil and lubricants, and other admissible dues, including hire charges of the vehicles, have not been settled. He has also referred to the fact that the members of the Foreigners Tribunal are not entitled to regular pensionary or post-retirement benefits, and therefore he is suffering from considerable financial hardship. A photocopy of the said letter is being handed over to the learned senior government advocate. Next by the learned counsel, learned senior counsel for this court has also submitted a bunch of letters written by various authorities to various foreigners tribunals functioning in the state of Assam for vacating the respective foreigners tribunals to carry out repairs and renewals, and to also vacate the premises and search for other suitable accommodations. Full stop. Copies of few of such communications have been handed over to the learned senior government advocate. Next I shall, the court is inclined to direct the Home and Political within bracket B department and the respective district commissioner to do the needful to stop. If it is very clear that if the repairs and renewals are urgent in nature, comma, it would be open to the state government to temporarily discontinue the functioning of those tribunals so that proper repairs and renewals are done. First of, however, it will be open to the Home and Political B department and the respective district commissioners to ensure that the repairs and renewals are done within the time allowed, and to resume the functioning of the tribunals on such dates as may be notified when the notified on the dates when the respective functionings of the foreigners tribunals are discontinued. Next paragraph. The state government is also having an alternative to first relocate the foreigners, those foreigners tribunals where repairs and renewals are necessary, to a safe location, to an appropriate and safe location, so that the functioning of the tribunals are not hampered even for a day. Full stop. However, comma, as the foreigners tribunals do not have the authority to stop its functionings of its own, comma, the respective the Home and Political within the V department and the respective district commissioners are directed to follow up the notices which have been served on the foreigners tribunals to vacate for the purpose of repairs and renewals or for permanently shifting from the premises. So, however, every action is taken shall be intimated to the learned senior government advocate, so that he may brief the additional advocate general for the state and to also produce a compilation of the communications before this court. What was the third letter?
Third
or that
Yes, AGP matter.
budgetary allocation.
This is dated mail of 18/5. Member Foreigners Tribunal 5, Durham Mall, Bengal.
The previous counsel for the court has also produced a copy of letter dated 18/5/2026, from a copy of which has been provided to the learned senior government advocate, by which the member, Foreigners Tribunal 5th, Darang, Mangalore, has stated that the assistant government leader had resigned, but till date, no assistant government leader has been appointed. Full stop. This, it has also been projected that there is a shortage of staff, and there are 4 vacant posts such as stenographers, data entry operator, office. And despite repeated communications, the posts have not been filled up. Full stop. It may be mentioned herein that there are judicial pronouncements of this court by which the foreigners tribunals are prohibited from cross-examining witnesses. And it has been clearly laid down that the foreigners tribunals would have power to ask questions, which is otherwise envisaged under section 165 of the Evidence Act and section 169 of the Bharatiya Sakshya Adhiniyam. So 168, Bharatiya Sakshya Adhiniyam. So therefore, if the if the assistant government leaders are not appointed, the functioning of those tribunals should be parasitic in nature. But there would be nobody to cross-examine the witnesses. Full stop. It is appalling to note that the Home and Political, within bracket B department, is very happy with that situation. And they have not taken any steps to appoint assistant government leader in the foreigners tribunal. This also demonstrates that the intention of the government is not to allow the foreigners tribunals to function in an appropriate manner, which is conducive for a judicial determination of the issues of foreigners tribunals. Full stop. If the foreigners tribunals do not have a stenographer, data entry operator, copyist, the court does not expect the members of the foreigners tribunal to act like one. Full stop. Therefore, we find it the court is pained to note that despite repeated reminders, the state government has not filled up the 4 posts. So accordingly, the court directs the appropriate authority whoever it may be, either either the Home and Political within bracket B department or the respective district commissioner to appoint stenographers, data entry operator in copies in all those tribunals who do not have where there is shortage of staff, to appoint such staff who are the appointment of which are essential for the operation of for the functioning of those tribunals. So the same shall be done within an outer period of 6 weeks, during which the state government will have to authorize this court to take up central recruitment for filling up all the posts of the staff under the foreigners tribunals in a centralized manner. Full stop. This order shall also be brought to the notice of the Chief Secretary to the Government of Assam, who is directed to monitor the issue of appointment of staff in all the foreigners tribunals functioning in the state of Assam. Full stop. The court requires an affidavit to be filed by the Commissioner Secretary to the Government of Assam, Home and Political B department, to inform the court as to whether the posts, all posts in all the foreigners tribunals have been filled up. Next para. For the said affidavit, there will be a separate date fixed, which will be indicated at the end of the order. So there are two orders. Number one, either they will do it or they will authorize the High Court to take up the centralized appointment, recruitment, and then we will do it.
One last point, my lord, regarding that books, for last 6 months, it's still not done. Supply of books and journals. my lord.
Journals.
Every time they have said that we'll do something, but no decision as of now.
The Learned Senior Counsel for this, Senior Standing Counsel for this court has also submitted that the issue of continuous supply of law journals and other essential books to the foreigners tribunals have not been done. Next paragraph. In this regard, we have already stressed on various occasions the requirement of supply of books to the foreigners tribunals. First of the orders of the foreigners tribunals are assailed before this court, and this court from time to time lays down by passing orders have laid down the law to be followed by the foreigners tribunals in their adjudicating process. First of, if the tribunals do not have access to the law journals of the law journals and the essential books, it would be very difficult to envisage a proper functioning of those tribunals. Accordingly, the Home and Political B department shall also take an appropriate decision in this matter within a period of 6 weeks. Next paragraph. Insofar as the issue regarding repairs and renewals and the shifting of the various foreigners tribunals, this is the matter again on. It will go after vacation this time, 14/7/2020.
Tuesday.
We have said earlier that after 6 weeks, we remove that. The range of this thing, it will be 14/7.
14/7 months, fine.
And Lordship, I think you mentioned about that order passed in the other case where for scarcity of ink, etc., that copy.
Okay. So that, no, this will be, I think, is Mr. Pang here? No. Mr. Pang was preparing a SOP. That can be
If
made
it
a
is-
part of that.
If
It
it
will
is,
be more better.
it is incorporated there, then I think it will
But
suffice.
what has happened to that? Those SOPs were required to be implemented.
One SOP was already prepared.
But what about the implementation?
I'll find out from Mr. Pai, possibly he is in touch with
Okay.
the department.
Just add on the next date of listing, the London Additional Advocate General also apprised the court about the SOP that was envisaged for the foreigners tribunals. And he would also examine as to whether the directions contained in the judgment and order dated 17/11/2025 passed in WBC 5229 of 2016 could also be taken note of while preparing the said SOP. Mr. Mazumdar,
Malik.
that will be okay?
Yes.
You have a copy of that order?
No, I will.
Okay. Ravi, these are order, just write it down. Order dated 17/11/25. Just note it down. You can give a printout to Additional Advocate General. Judgment and order dated 17/11/2025 passed in WBC 5229 of 2015. Just give a copy to me. Mr. Das, anything you have left out?
No, no, everything has been covered.
Mr. Dhar? Everything is good. Okay.
Well, next date instead of 14, because first 2 weeks can be on 16 or 17, otherwise.
16th is okay.
Yeah.
No problem. 16th.
After reopening, 4-5 days of time will have.
It's okay. We can give it next week also, 21st also.
21st, madam.
21st.
16th Thursday, Sunday.
Okay, 21st.
21st, madam. No, যেহেতু আমাকে লম্বা টাইম হয়ে গেছে
Serial order. Serial.
also in the last. No, no.
We are aware of that also.
Detail can you share?
We'll share the details with.
Madam. 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 Okay.
Mathur.
For motion, item 13.
For my land enforcement start, I have instruction to appear on behalf of the opposite party in this case. Lordship, definitely my junior is.
Malo. 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 That will be very good. Malo.
Yes, that can be, because this is the mandatory part.
Malo.
Lordship, yes, yes.
Malo. 41 sub rule 5. Order 41. Malo. Malo, yes. Yes, sir.
N का कुछ नहीं, N का कुछ नहीं.
N का पट्टी. N का. No, no. Morning lordship, I.
So, my lord, what has happened, it is still pending for adjudication. Yes. Well, this review was filed on 4th of November 25. My lord, that is at page 40, my lord. What had happened, there was a conditional admission of the appeal. So my learned friend had come up, we said that is perverse and that was set aside immediately. So that cannot be.
The matter was remanded back to the learned appellate court for passing place order.
Because when the order was passed, we were not heard on 41.5. So,
What's it? No, we are depositing rent in that. Okay, that's the condition order was that we approach this. It is. That is all. Yes, Lordship, that is, that, in that case. Yes, Lord.
I was also surprised when I saw that they have filed a CRP. I thought they are better safe in this order. But the order was perverse because of the reason that it was the condition. Yes.
Correct.
Okay, for one thing probably disturbing me, because they file a review petition and their review petition it is fair that clarify the judgment and declared so and so. To the effect that the plaintiff citizen is entitled to receive area rent and enhanced rent of 10% every 2 years till the date of actual eviction. So
Yes.
it is still pending. So Lordship has. No, Lordship. Till date, Lordship, they have not filed any cross.
No, no.
No, still they can file. Till that, Lordship is all. Lord. Lordship. But regarding stay, Lordship, that will continue. Normal stay. Lordship.
Five, 26, five. Bharat, may I submit one thing? Only interference to the extent that stay without any money, only that we require. That may be observed. Because stay, Bharat,
Lordship.
Bharat.
Lordship.
19/5/2026.
19/5/2026. Lordship.
Bharat, in one place, perhaps it is district judge, it must be additional district judge, in one place. The second case also same, unless only the case number that is. I'll give that.
Much okay.
So very grateful, Bharat. I'll give it. Bharat.
Supplementary item 14 for motion. Item 15 for orders.
The respondent have filed
affidavit of opposition today, Your Lordship. We need some time to file reply, Your Lordship.
Obliged.
They released item 2 for hearing.
Logically.
Yes.
Also, we have preferred the money suit in the year 2003, which is at page number 13.
Who is the plaintiff?
Lordship, I am the plaintiff.
Okay.
Basically, the facts of the case is that the defendant was running a sawmill and he was under financial crisis and have taken help from me. Lordship, may kindly see page number 13.
What is that agreement?
Lordship, the agreement dated 7/7/2002 is exhibit 1. In the lower court records, it is at page number 77. Or 57, sorry.
What is the date of the agreement?
7/7/2002.
7/7/2002. Yes.
Lordship, based on this agreement, he has never returned our money, Lordship. Thereafter, we have filed the suit which was decreed in my favor. Thereafter, they have gone for the appeal, where the judgment was reversed, Lordship.
Yes, the appellate court reversed it.
Yes, Lordship.
On what ground?
Lordship, that there is no partnership deed and the partnership is not registered. And the other is that this agreement dated 7/7/2002 is not registered under section 49 of the Registration Act. That is at page number 31.
But then, you see, what has happened is that while deciding on this exhibit, that is the deed, which is exhibit one. This is exhibit one, right?
Lordship.
There is a finding of fact by the learned trial court that this was you entered into a partnership. Now, if that is so, against that, there is no cross objection to that finding. Therefore, what happens is that you are a partner in that firm stands affirmed. Your suit is not for rendition of accounts. So there are decisions of this court as well as Supreme Court which says that if it is a suit for rendition of account, then even non-registration of partnership should not be fatal. So your case is not for that.
Lordship, because there was no partnership firm, there was no partnership deed, Lordship.
But that finding of fact
It was
remains.
only this financial help.
But the issue number two, see, come to page 14 of your memo appeal, whether the plaintiff is a partner, that is in affirmative. Page 15 is the reply. Sorry, the discussion. In discussion says the operative part is at page 16. The findings start from fifth or sixth line. The plaintiff agreed on payment to condition of a partner of the said sawmill. That is at paragraph 7, issue number 2, fifth line. And then in the page 15, the last part of that discussion. In such case, the plaintiff has established that the partner of the defendant in respect of the sawmill, as the defendant did not adduce any evidence, his plea of denial cannot be accepted trustworthy, and the issue is decided in favor of the plaintiff. So, when you are asking for money simply cited, this issue should not have been there at all. But once it is there and decided, then you see then the suit itself is defective, because then it should be always be a suit for initial of accounts and for share. So from once you are the partner, you cannot sue yourself for money.
That's. But there's no partnership deed, no partnership
So you understand,
firm,
the
nothing, Lordship.
deed does not say to be a partner, but then you call this upon yourself, this.
Yes, Lordship, but
In second appellate stage, you will find it very difficult.
only on the basis of this agreement, 7/7/2000.
That agreement could not have been held to be a partnership deed.
Yeah, because actually there's no partnership deed and no partnership firm. It was,
Against this finding, there was no cross appeal.
that is not there. Lordship.
Because in second appeal, we cannot reappreciate the evidence.
Lordship.
We only have to answer the specific question of law. You see the first appellate order, then we find no reference to the disowning of the partnership. That's something to be known, the participant, partnership, partnership. But we have to dismiss it. Right. As provision of the we'll record your presence through Mr. Aslam,
Mr. Jain Sahewala.
Mr. GN sir, okay. Depending on under instructions from Mr. GN Sahewala, the senior counsel for the appellant. None appears on call for the respondent. Next paragraph. This appeal under section 100 of the CPC was admitted for hearing by order dated 22/3/2010 on the following four substantial questions of law. Next. Next one. The facts as appears from the pleading made in the plaint is in a very narrow campus. The case of the appellant is the plaintiff in MS1 of 2003. So the case of the appellant in the plaint is that prior to the year 1999, the respondent, with the consent of the father of the appellant, installed a sawmill on his land, and since then, the respondent was running the said sawmill till March 1999, when he faced acute financial hardship and accordingly approached the petitioner to help him financially, and accordingly the appellant invested a sum of rupees 50,000 with a condition to jointly operate the sawmill. Accordingly, on 12/4/1999, the said advance of rupees 50,000 was paid to the respondent and entered in and agreed to comply with all the terms and conditions of the agreement. The said agreement was entered said agreement It is projected that as per the said agreement, the petitioner, along with the respondent, was running the said sawmill till February 2000, and thereafter the respondent became a defaulter in paying the share of profit of the said sawmill and deserted the appellant and the business without assigning any reason. So accordingly, as per the statement of accounts as maintained by the respondent in ordinary course of business of the said sawmill, sum of rupees 72,013 was due to the appellant as area of profit from 3/3/2000 to 17/3/2003. So it is permitted that the respondent without making any payment, close this business and promise to pay areas of profit and capital amounting to rupees 20,000 within a year, and entered into an agreement dated 7/7/2002. Acknowledging, thereby acknowledging the said outstanding amount due to the appellant. As sum was not paid, suggesting that the cause of action arose on and from 12/4/1999 onwards, on 7/7/2002, and on various dates on which demands were made, the appellant had filed a suit which was registered and numbered as MS number 1 of 2003 before the learned civil judge within bracket senior division, Sivsagar, paid for decree for the amount as amount of rupees 1,25,000 as described in the schedule of claim, with interest at the rate of 18% per annum, including final payment and costs. Full stop. Next paragraph. In course of trial of the suit, the respondent filed a written statement, and upon pleadings, the following issues were framed for trial. Page 14, 1 to 5. Full stop. In support of his contention, the appellant had examined 3 witnesses namely the appellant, Sri Nogen, Nogen, Nogen Bhuyan, Bhuyan, PW1, Sri Jonathan, Jonardn, Borua, Buh, as PW2, Sri Niren Chandra Datta, PW3, and who were all cross-examined, and the evidence and exhibited the agreement for business dated 7/7/2002 within bracket exhibit 1. And signatures thereon as exhibit 1/1, TO2, exhibit 1/8. Most of the respondents did not reduce any evidence. Most of the learned trial court writes judgment is decreed in 25/5/2007. Decreed the suit by holding the appellant entitled to get ₹72,000 along with principal amount of ₹50,000 and interest at the rate of 10% per annum from the date of institution of the suit till full and final payment. Next by may be stated that in respect of the issues referred above, the issue number 1 was decided in the affirmative by holding that there was cause of action for the suit. In respect of issue number 2, in view of the contents of exhibit 1, it was held that the appellant had established that he was a partner of the respondent in respect of the sawmill business. And as the respondent did not reduce any evidence, his plea of denial was not accepted as trustworthy. And accordingly, the said issue was decided in favor of the appellant. In respect of issue number 3, it was held that the suit was not backed for non-jointer necessary parties. In respect of issue number 4, it was held that the suit was maintainable. And in respect of issue number 5, help of the petitioner is entitled to a decree and referred above. Stop. Next paragraph. The respondent was agreed by the said judgment and decree dated 25/5/2007. Referred an appeal which was registered as money appeal number 4 of 2007. And the learned additional district judge, Sipsar, by the appellate judgment and decree dated 4/11/2009, reversed the finding on account of exhibit 1 by holding the said agreement to be a partnership deed, which was compulsorily required to be registered as a under the Partnership Act. And therefore, holding that the suit was not for suit for account. Comma. The finding and decision of the learned trial court was reversed by holding that there was a statutory bar under section 69 within bracket 2 for declaring the suit in respect of the partnership which was not registered. But further holding that there was no registered partnership firm and the deed was also not, and the agreement was also not registered. First of all, agreed by the said first appellate judgment and decree, for which the appeal was allowed by reversing the decree passed by the learned trial court, or the recent appeal has been filed. Next for that. The learned counsel for the appellant has painstakingly submitted that the contents of the agreement, which was exhibited as Exhibit 1, could not have been read as a partnership agreement by the learned first appellate court. Therefore, arrived at a wrong conclusion, which has vitiated the impugned judgment. It is submitted that the suit was a simplified money suit seeking for recovery of the sum of rupees 1,25,000 with interest at the rate of 18% per annum. And no deed was sought for rendition of accounts, and therefore the learned first appellate court could not have given a contrary, could not have given a finding contrary to the prayer by holding the agreement between the parties to be a partnership agreement, and thereby dismissing the thereby allowing the appeal and dismissing the and setting aside the ex parte, sorry, the judgment and decree passed by the learned trial court. Anything else you wanted to say?
No.
That's having regard to the nature of evidence which was led before the learned trial court. So it is seen that while deciding issue number 2, the learned trial court took into account the evidence of the appellant, where he had stated that he was a partner in the Solomon business, and that as the business was and the due to financial crisis, he had given the loan to the respondent. So accordingly, it was held that the agreement marked as Exhibit 1 was executed by the respondent in favor of the appellant, which also shows the state contention, meaning thereby that the agreement was for a partnership between the appellant and the respondent. Accordingly, in respect of issue number 2, there is a categorical finding by the learned trial court that the appellant was the partner of the respondent in respect of the sawmill business. Full stop. Next paragraph. In respect of the said finding on issue number 2, there is no record of any cross objection being filed by the appellant to assail the finding of the learned trial court on issue number 2. Full stop. Therefore, as there was a specific issue on the specific issue number 2. Same as to whether the plaintiff is in fact the appellant hearing, like it is a partner. The same was answered in the affirmative. There was no challenge to the finding on issue number 2 by the appellant. The learned trial court as well as the learned first appellate court proceeded on the premises that the exhibit number 1 was a unregistered partnership agreement. Next, accordingly, as the suit was not for rendition of accounts. This was a case where by virtue of the finding by the learned trial court, the petitioner was, the appellant was suing the respondent as the defendant in his capacity as it was I was present the respondent, claiming on the basis of exhibit 1, which is a partnership agreement. Under the circumstances, the finding of the first appellate court that there was a bar under section 69 within bracket 2. As a partner of the firm, to enforce the right is not found to be illegal or perverse. Accordingly, the learned first appellate court held that it did not agree with the finding of the learned trial court and held that the suit was barred by existing and established principles of law by referring to section 69 within bracket 2 of the Partnership Act. Next one was the suit filed by the appellant is not for rendition of accounts. There is a categorical admission that he was a partner with the respondent in respect of the timber business, or sawmill business. The court is of the considered opinion that the suit filed by the appellant as partner against the another partner of the partnership firm is hit by section 69 of the Partnership Act, as the said partnership was not registered and the present suit was also not a suit for rendition of accounts, and therefore the suit will be hit by section 69 of the Partnership Act, as the partners would be representing itself as well as the partnership firm. Accordingly, the substantive question of law number 1 stands answered in the affirmative by holding that the suit is hit by section 69 of the Partnership Act, as the firm was not registered. Next, in respect of issue number 2, is also decided against the appellant by holding that as it is the case of the appellant that exhibit 1 admitted him as a partner, the non-registration of the said agreement will be fatal to the appellant. So accordingly, the substantive question of law number 2 is also answered accordingly against the appellant. Next, in respect of the substantive question of law number 3, court is of the considered opinion that while deciding issue number one, the learned trial court had referred to the agreement dated 7/7/2002 within bracket exhibit one, confirming the area of profit towards capital invested by the apparent and the outstanding area to the extent of rupees 1,22,013 as on 7/7/2002. So stop. While deciding issue number two, the finding in respect of the agreement marked as exhibit one refer to the solid business and share of profit arising therefrom. So, in respect of issue number four, while referring to exhibit one, it was referred to as an agreement by the respondent whereby he agreed to pay the principal amount to the tune of rupees 50,000 together with the profit of their business of a total amount of rupees 72,000. Similarly, issue number, while deciding issue number five, exhibit one was referred to as an instrument showing the appellant entitled to rupees 72,000 from 3/3/2000 till 17/3/2002, together with principal amount and interest carrying thereon. Therefore, the substantial question of law number three is answered in the negative by holding that while discussing the issues framed in the framed by the United Trial Court, exhibit one, it was not in respect of immovable property. However, the United First Appellate Court, while referring to the exhibit one, when is the finding was today about First Appellate Court referring to as the agreement for immovable property?
Lordship, at page number 31, paragraph number 12. Starts and continues to the next page, 32.
No, but it's not for agreement, it's for registration. Okay, section 49 has been referred.
Yes.
Okay. So this the, finding recorded in, by the first appellate court in paragraph 12 of the impugned first appellate judgment. By referring to section 49 of the Registration Act. Appears to be an incorrect finding. And the bar to and the bar is created not by section 49 of the Registration Act, but as section 69 within bracket 2 of the Partnership Act. So stop. The so is there any finding of thunderstorm? Huh? Oh, oh. Okay. Thank you for the information. Extreme red,
There's a alert, Lordship,
extreme red warning. Okay,
extremely severe alert.
okay.
At isolated places over Kamrup in next 1 to 3 hours.
Mr. Chaudhary,
I was just talking of the sound, I just ran out.
you have to go home, search for your bed, and you have to sleep underneath your bed.
My lord, I just told my lord, there's a thunderstorm, my lord, approaching.
Yes. Next, just comma. As there was no cross appeal against the finding on issue number 2 to hold exhibit 1 to be a partnership agreement, comma, and the suit filed by the appellant not being a suit for rendition of accounts, comma, the subsidiary question of law number 3 is answered by holding that all through when the discussion on exhibit 1 was in respect of the partnership firm, comma, the reference to section 49 of the Registration Act is merely an inadvertent error, which does not affect the merit of the finding. And therefore, would not be fatal to the decision of the learned first appellate court. So the said question of the subsequent question of law is answered accordingly, that the inadvertent error in referring to section 49 of the Registration Act is a mere inadvertent error which does not affect the merit of the finding. Next paragraph. There's no substantive question of law is raised, comma, the substantive question of law number 4 need not be answered, as no such question arises for decision of this in this appeal. Next, resultantly, comma, the appeal fails and the same is dismissed. To stop under the circumstances, comma, there shall be no other effect. The registry shall send back the records to the respective records to the learned trial and the trial court and the first appellate court, along with a copy of the order to be made as part of record. The registry shall in course of time draw the decree for dismissal of the appeal. And notify the and notify accordingly. Yes, you wanted to say something? Resume post lunch.
Yes. My lord, it was shocking about my lord, section 69 on the partnership act. I was just reflecting on the state loan currents case point of 77 Supreme Court, which was the first in line which said that, my lord, until and unless the firm is registered, my lord, the bar is a mandatory, my lord, and there cannot be, my lord, any.
Item 3 for hearing.
My lord, in this matter, I appear for a respondent. So the permission will be.
Make this order, sir. Also, I have given FLC for it. I think to mention item number 18 also. I have taken a consent from the other side also. 18. I've got a response. S.A. Bhaktiyar. S.A. Bhaktiyar. The respondents. N. Alam.
June. 19 June. 19. All right. In this matter, my lord, I am waiting for the respondents, my lord. The respondent number 1, my lord, he expired. Yes, my lord. He expired on, my lord, 2/3/25. 2/3/25, and thereafter, my lord, on 22/5/2025, we have filed an application under Rule 10A, my lord. Intimating the, my lord, petitioner, appellants about the, my lord, legal errors, my lord. Thereafter, till date, my lord, no application for substitution or, my lord, for setting aside of the abatement has been filed, my lord. It is my respectful submission to them, my lord, that the entire proceeding has abated, my lord.
My lord, in the meantime, my lord, during pendency of this, my lord, appeal, appellant number 1, 6 and 8 died, my lord. They have communicated just before 2 days, my lord. They are coming today, my lord. This, my lord, the heirs of this 3, my lord, appellant, they are coming today. So, my lord, I will file 1, 6 and 8. 1 Haridas Datta, 6 my lord Gauranga Das, and my lord 8 Haren Das.
So he is submitting, and he submits that he's in touch with the legal representatives of the deceased appellant number 1, 6 and 8 who are arriving to do the needful. Full stop. Next paragraph. Mr. G. Chaudhary, learned counsel for the respondent, has submitted that the respondent number one
Promote data.
had died on 2/3/2025, and accordingly, an application was filed by the learned counsel, by him,
Not by me, by the earlier set of councils, my lord.
by the earlier set of counsel under Order 22, Rule 10A.
23. 23, my lord. Order 23, Rule 10A.
It will be 22.
22.
22, 10A of the CBC on 22/5/2025 to bring on record that during the pendency of the appeal, the respondent number one had died on 2/3/2025. Full stop. It is submitted that that as the learned counsel is appearing for the deceased respondent number one had discharged his duty under Order 22, Rule 10A of the CTC. The present appeal has awaited. Full stop. Next paragraph. Having regard to the fact that Mr. Khan, do you know about the date of death of respondable, the appellant number 1, 6, and 8?
Only one, my lord, Gauranga Das, 23/12/15, man,
23,
12/15. December 15,
for respondent number 6,
6 years. But other dates I do not
and 1 and 8 you don't know.
know, man. Other dates.
And that the respondable 8 stated to have died on 23/1/2025, and is not aware of the date of death of respondent number, sorry, appellant numbers 1 and 8.
My lord, since this appeal was my lord conducted, senior counsel G. P. Najai, my lord, he is
No, it's okay.
expired, my lord.
No, no, it's okay. We are not on that.
I- Okay. Okay.
Your, that application is not on record.
That is not on record. There is a report, my lord, which is tagged, which has been tagged along with a orange color flag, my lord, Rochester kindly see, my lord. The registry says that there is some defect in that, my lord, application for which it is
No,
not.
no, you see, here it says learned counsel for the appellant has filed interlocutory application.
My lord,
Appellant
that is wrong. You have-
is Mr. Chauhan. And that is lying, the 14016, the same is lying in the filing section awaiting rectification or defects.
My lord. I was not aware of that because at that time I was not my lord, engaged in this case, my lord. I was just engaged the other day, my lord. Perhaps from 6-5 or 5-5, my lord. Around 7-5, I made my first appearance in this case.
Just take off from the, just take off from our. You see, online with that. Is any application filed in this appeal on 22/5/25? RSS 65, item 3. 22/5/2025.
But he had received a copy of this application, my lord, which apparently was filed. He has received a copy of this application.
No, receiving and the filing are two different things.
But definitely, my lord. No, what I mean to say is that it's only the, my lord, that the information that is to be given. So,
We
and
don't
need
know
to
what-
act on that.
Not available. Not available. No, most applications. You just mentioned that how no application is available on record.
My God, sir. Because on the other day also Rupen was there with me, he stated that he had filed it. I don't know.
I don't know.
But then he has received a copy of this application.
Whether assuming as the fact is recorded as the depth of the, number one is recorded in the order date is 7/5/2026. Disclosing the date of death on 2/3/2025. Amount. Appeal is awaited. Next para, however, comment. As the non-counsel for the appellant pays for some time to take instructions on the matters to adjourn today. So this being an appeal of the year 2010, my long cannot be granted. Next for this term, your date after 2 weeks. Just wait till he give a date.
24.
No, I don't control now, like give 2 weeks.
2 weeks, 2 weeks, no, about
2 weeks, because this 2010 matter.
15, 15, yeah. 15, yeah. 17th of, my lord.
Yes, item 5.
In this case, I am the appellant defendant. The plaintiff filed the suit, it was decreed in his favor. And thereafter, I filed an appeal, the appeal also dismissed. So thereafter, this second appeal. The second appeal was admitted on 2011-2015, following one substantial question of law.
Whether the plaintiffs have acquired prescription under section 25 of the Limitation Act
But it is not complete. On substantial question of law was framed on 2011-2015.
Whether the finding of the learned courts below that plaintiffs are required right by prescription under section 25 of the Limitation Act
Limitation Act.
is whether it will be correct or perverse. That's okay, doesn't matter.
So, the suit was suit
The judgment, what was the issue and how was it decided in the appellate judgment?
in the appellate judgment, issue number 5 and 5, case 57. Case 57.
Is the face map of the suit land available on record?
Yes, this map is not on record. They have given one map in the suit itself, which is at page 15. Along with the plane, they have drawn this map. The schedule A and house, which is below is the plaintiff. The schedule below is the suit land. Schedule B is the suit land and land of house of defendant of defendant. On the north, and there is a railway land. So they are basically claiming right over this schedule B land.
Okay. Okay. Yes.
Lordship, the pleaded case of the plaintiff was that the original owner of the land was Mani Kumar Pradhan and his brothers. And from him, the defendant, the pro forma defendant number one, Dinesh Roy, purchased the land, white sale deed number 2494, dated 23/12/1986. By way of this registered sale deed, 23/12/1986, the pro forma defendant number one purchased the land from Mani Kumar Pradhan.
Purchased land.
That pro forma defendant, Dinesh Roy.
From pro forma defendant number one.
I have, the plaintiff has said from the pro forma defendant number one.
That's fine.
So thereafter in the year 2006,
Just one minute. Yes, this is what is the date?
the date is 23/12/1986, the pro forma defendant purchased,
The former defendant number one purchase.
one purchase. So thereafter, the pro forma defendant sold the land to the plaintiff on 27/9/2006.
On
27/9/2006.
23/9,
27/9/2006.
27/9.
They have stated that they have stated in their plain that when the plaintiff pro forma defendant number one purchased the land in the year 1986, Mani Kumar Pradhan allowed 2 cubic wide pathway to the land, suit land.
Who provided?
That Mani Kumar Pradhan provided 2 cubic wide pathway stroke passage to this pro forma defendant number one.
What is the name of the vendor?
The plaintiff's vendor is Dinesh Roy.
No. So former defendant number one's vendor.
Mani Kumar Pradhan and his brothers and his brother. That is in page 11, paragraph 2.
Yes.
After 1986, the pro forma defendant number 2 purchased the Schedule B land. Schedule B land and expanded the said path or passage to 7.5 feet road. 7.5 feet to the Schedule A, which they are claiming as suit land now. Therefore, the pro forma defendant number 2, so by way of Nibida Patra, transferred the land to the defendant. In the year 2002, the pro forma defendant number 2 transferred the land to the defendant. They have said that
Just a moment. Wrong. Mr. Mukherjee, something is wrong. Because I'm not being able to follow. The reason is that the link deed of 23/12/1986, by virtue of which the plaintiff purchased the land, that has not been exhibited.
No, no, that's not your knowledge.
86 is not the plaintiff document, your lordship. By the 86 deed, the vendor of the plaintiff purchased the entire land. Lordship may come to page
Who is the
11
plaintiff? You are the plaintiff.
and the plaintiff. 86 document is about the vendor of my vendor, your lordship.
This is a link document.
Link.
You say that you had this part then.
Lordship.
If that part is not shown, then the substantive question of law has to be answered in the affirmative.
Lordship, that was clarified later on as well. After that purchase, my vendor purchased the B-schedule land as well. The land that is occupied by the defendant. And thereafter, by way of a Nidavi Patra, my vendor sold the land to the defendant, leaving aside 7.5 feet road.
Just one thing I want to point out, your lordship. The exhibits are not here, lordship.
No, that's okay. It may not be there, but the evidence otherwise is available. These things are not on record. We don't find that the evidence is there to
86.
that effect.
86 document is not complete.
You see, this exhibited documents,
Case 30.
exhibited documents are registered sale deed of 27/9/06. Exhibit 2 is certified copy of the mutation order. Exhibit 3 and 4 are electricity bill. 5, 6 electricity bill. 7 is Nabadi Patra. We'll come to that later. 8 is the judgment in TS 8 of 07. 9 is again TS 8 of 07 decree. 10 is plaint and 10(1) is relevant part of the plaint. So the sale of the land or the purchase of the second land is not
It is
there.
not exhibit.
Then your prescription fails.
Lordship,
You are relying
this
on
is,
section
this is
25.
not only about prescription, your lordship. Initially, there was, lordship may come to the facts, your lordship, at page 11 of the plaint, your lordship.
No, no. When you are seeking an advantage of section 25 of the Limitation Act,
Lordship.
for that you have to show something. Can by oral evidence you will prove the, can you prove the prescription under Limitation Act section 25? You see, because when Mr. Chaudhary was arguing, I am not being able to follow because
Lordship,
these things are not as per the exhibit.
Lordship, if I may briefly place the facts, your lordship. This is an issue, your lordship, because that initial deed is not before this court. That is not, that was not even exhibited. In 86, the land was.
You see, that is not there. Number one, the original landholding which was there when exhibit, when the initial sale of the 86 and 2006 was made, that we don't have. Then the subsequent purchase we don't have. The corrections and the amount of land which is available in the Dagan Pata by way of Germany we don't have. So therefore it is only oral evidence.
Deeds are there, your lordship. Only the deeds,
Not
subsequent
there.
deeds.
Not there.
Right.
The only exhibited document is 27/9/06.
by which I purchased the land, and the Nidabi Patra, which is their title document.
You forget about that. You will have to stand in your own legs.
That's all.
Now, if the document is not there, how do you prove the landholding and the subsequent use of that land as a road? Don't find anything.
That aspect is still one.
And there is a clear denial regarding the use of parts by the performer defendant in my WO.
No, to that effect, there is no evidence. Again, for you also the same thing applies. How do you prove? Can section 25 prescription be committed by an overall evidence?
They have to show that they were using the parts or their profits, their vendors were using the parts since 20 years without any interruption.
That is the problem. Be prepared, that is the only issue. We'll take it up day after tomorrow. And give me both sides will give me a list of relevant dates or events. Not more than 2 pages.
Yes,
Don't make an elaborative argument, we will not accept it then.
that's it.
Only the list of dates.
List of dates or bullet points, but not illustrative arguments.
Let's take for Tuesday also. Tuesday,
Next Tuesday.
next Tuesday.
9, 9.
Mr. D. Chaudhary, I'm counsel for the appellant, and Mr. B.J. Mukherjee, I'm counsel for the respondent. Next, for the record. Of the C15 of the learned trial court, it appears that the exhibited documents are as follows. Registered sale deed dated 27/9/2006 within bracket exhibit 1. Certified copy of mutation order dated mutation order is still within bracket exhibit 2. Electricity bill and payment receipt within bracket exhibit 3 TO2 with 6. Certified copy of Nibadi 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 Patrol within bracket exhibit 7. Judgment and decree passed in TS 8 of 07, exhibit 9 and 10. No, it will be exhibit 8 and 9, 8 and 9. And 10, copy of plaint in TS 8 of 07 within bracket exhibit 10. Stop. The exhibited documents are not available. Let's find out from the submissions made by the learned counsel for the appellant. It appears that the plaintiff respondent's vendor had purchased the land in question on 23/12/1986 at B schedule land. B schedule land, 23/12/1986. Which is not exhibited. You have the documents, exhibited documents also with you or no? If I mentioned that there is no order in the order sheet regarding return of the exhibited documents. There's also no order in the order sheet of PA 8 of 2012 regarding return of the documents. Therefore, the court is compelled to record that the matter would be heard on the basis of materials available on record and depend on the, and the court would depend on the evidence of the witnesses examined by both sides. Accordingly, both sides are put to notice on the point. Next para, on the next date of listing, the legal counsel for both sides shall provide short synopsis of their synopsis of the bullet points of their submissions without any argumentative material to stop them. Next para, the legal counsel for both sides shall in the meantime shall take all instructions as to whether the copies of exhibited documents can be provided by the respective parties. The defendants exhibits are also there.
Defendants did not exhibit any evidence.
No documents are exhibited. And produce copies thereof. That's established on. The communication order, how much time will take? About the availability of documents you will cite. And they have order reconstruction data.
A week's time.
Okay. So it is on the same day.
Nine.
9 June. I think so. 11, 9 days other fixed matter.
Item 6.
May I please your lordship? Lordship, due to my senior's daughter medical emergency, my senior's daughter's medical emergency, he could not appear before this writing for today. This matter may be taken up day after tomorrow morning. I have taken consent in the other side.
On the ground that the council holding will be is that's a medical emergency for which I could not appear. But the matter stands adjourned today. Which was represented. List on, take it day after tomorrow.
And your
Item 7.
Tomorrow.
may please your lordship. May please your lordship. Lordship, here in this matter, adjournment was called for in the morning due to my apologies, lordship.
Yes, because this is item number
Lordship.
7. So this is 2018 matter.
Yes, lordship.
I find it very difficult.
Yes, lord.
Yes, Mr. Opinion.
Yes, lordship. Lordship, this case has been preferred due to this impugned order, lordship, which is at page, lordship, 50, lordship. It starts from 50, lordship, wherein I being the decree holder, lordship. May I read, sir?
Just a moment. It's a family dispute.
Lordship, here what happened, lordship, the marriage of the petitioner and the respondent was solemnized in the year 1964, lordship. Thereafter, lordship, in the year 1984, the respondent, lordship, deserted the petitioner, leaving the minor children under the custody of the petitioner.
Marriage solemnized on
6/6/1964.
6/6/1964.
Yes, lordship. Thereafter, lordship, in the year 1984,
Respondent abandoned.
yes, lordship, respondent abandoned, leaving the minor children under the custody of the petitioner, lordship, the son. Then, lordship, in the year 1986, the respondent filed a case for maintenance. And lordship, till today, lordship, an amount of ₹1,000 per month is being paid by the petitioner to the respondent, lordship.
Maintenance of rupees.
1,000. As of today, lordship, so far as my information.
No, from which date to which date?
Lordship, It was filed in the year 1986, Lordship. But Lordship, till date, Lordship, we are staying, Lordship. There is an execution. Thereafter, Lordship, the petitioner retired from his service in the year 1997 as senior mechanical engineer, Gauhati, under Gauhati Refinery. Lordship.
What is the maintenance amount?
It is, Lordship, 1,000 rupees per month.
Yes.
Then, Lordship, almost after 11 years of his retirement, Lordship, the petitioner, Lordship, filed a divorce case bearing FC Civil case number 151 of 2008. Lordship, this case was filed in the year 2008, March of 2008. Then, Lordship, on 8/1/2014,
Just a moment. Yes.
then on 8/1/14, Lordship, the petitioner, the petition of the petitioner, Lordship, which was under Section 13 of Hindu Marriage Act 1955, was allowed on contest, dissolving the marriage between the parties. However, Lordship, the petitioner was directed to hand over his car and to make alternate arrangement to stay the respondent, as the petitioner agreed to do so in his cross-examination, Lordship. That, Lordship, cross-examination, that admission part, Lordship, the order starts at page 27. And Lordship, the operative part is at page 31, Lordship.
Which page?
Page, order starts from page 27.
Yes.
And the operative part is page 31, Lordship. May I read, Lordship?
Yes.
The point number 7. Order. In result, the petition under Section 13 of Hindu Marriage Act 1955 is allowed on contest, dissolving the marriage between the parties forthwith. The petitioner is directed to hand over his card and to make alternate arrangement to stay the respondent. Prepare a decree accordingly. So this was ordered, Lordship. The decree, Lordship, page 33, type copy of the decree, and 34, Lordship,
Yes.
is the decree. It is ordered and decreed that the petition under Section 13 of Hindu Marriage Act 1955 is allowed on contest, dissolving the marriage between the parties with effect from order dated 8/1/2014. The petitioner is directed to hand over his car and to make alternate arrangement to stay the respondent. This was the order, Lordship. Then, Lordship, the respondent filed a title execution case number 3 of 16. For Lordship, handing over the car and the alternate arrangement that was ordered to the petitioner. Then, Lordship, by petition number 383 of 18 dated 19/2/2018, Lordship, the opposite party, the petitioner herein, Lordship, he has stated that he has already handed over the car, and Lordship, at para number 3, Lordship, page 46, Lordship, para 3. May I read, Lordship?
Yes.
Lordship, para 3 of that petition, Lordship, 19/2/2018, that in pursuance of the aforesaid order, the alternate arrangement of accommodation for petitioner slash judgment debtor is now ready, and the petitioner judgment debtor can take accommodation in the room that has been constructed inside the compound of the opposite party decree holder. Hence, the opposite party decree holder has satisfied the decree passed in FC Civil Case Number 151 of 2008. Thereafter, Lordship, the petitioner filed, the respondent herein, Lordship, has filed an objection, and by the order,
Is the copy of that, is the photocopy of that, photo of that room available with you? No.
Lordship, thereafter, what happened, Lordship, since the petitioner is of old age, Lordship, and she also did not wanted to go there, Lordship, and stay. So, Lordship, now that conditions, Lordship, I tried to communicate, and later on, Lordship, just recently, Lordship, I was told that those rooms are currently not available, Lordship, and not in a proper, but they have stated that the son of the petitioner, Lordship, has stated that he will make all necessary arrangements for stay of the.
The answer is very simple. We have asked you that question looking at the affidavit, additional affidavit of the petitioner. This was filed on 18 or 16, the date I could not get. 10/10/18. You have a copy of that?
10/10/18.
You filed an affidavit.
Yes, Lordship.
Yes. At page 6 is the
Yes,
photograph of
Lordship,
the room.
this rooms, Lordship.
Yes, we can very simply say that you can shift, it's a very wonderful house. You can shift there and you can, the house, you can give it to Mr. Sharma.
No, Lordship, since there was a specific direction of the court.
I understand, but you retired as an engineer.
Yes, Lordship. The pension is around 2,500 something, of which, Lordship, I am paying 1,000 as maintenance, Lordship.
You understand, but you see, this is a very, what a wonderful room. Can be conveniently exchanged. You can go here and
Lordship, but the order was to accommodate her, to give her an alternate accommodation, not
But
specifically
that-
to it,
this,
but this order has gone beyond that decree, Lordship. This order
this order,
wherein it has stated that give her 2 rooms in the second floor, first floor, Lordship.
no, because you see, she is an estranged wife. You can't allow her to room like that. Alternative room means you could have got any space anywhere.
Yes, Lordship.
You could have arranged for the rent and all and give them anywhere. This is not an accommodation.
No, that is why, Lordship, what my latest instruction is that they are ready, provided, Lordship, there is a compromise or a negotiation with the Lordship respondent. They are ready to give her some place for residence, Lordship, where she can live, Lordship, with dignity, Lordship, not.
No, but that is not possible. You'll have to give us an offer. You see, you have to give a concrete offer. Then we'll see if it can be negotiated. The petitioner
Yes, Lordship.
is now 79,
The petitioner, yes, Lordship.
correct?
Yes, Lordship.
So the respondent would also be about 75 or
I'm hearing 70, yes, 75.
76.
76.
76. So you have to, for a room which is befitting for her.
In that case, Lordship, can this matter be posted in the next week, Lordship? I'll come up with a definite,
Because this is a degree.
yes,
It
Lordship.
will bind even the family members or others, supposing even if the petitioner dies. The state would be bound by this.
Yes, and Lordship, they are also willing to give, but that Lordship talk, there needs to be some communication between the parties, Lordship.
It can't happen now. I don't expect anybody to have talking terms.
No, Lordship,
Litigation since, what do you call,
84.
1984.
No, with the son, Lordship, she is still in talking terms. So, Lordship, they is saying that they will provide of their own, Lordship. Some,
First, let us an offer. This is something vague, we will not adjourn on that. Take it up next week, in the meantime, you get us the
yes,
information.
Lordship, something Lordship, specific Lordship.
Because with this offer, even sending for mediation of settlement would be impossible. We don't see that.
Mediation, otherwise also it is not possible because the petitioner and the respondent, they are not in very good condition, health condition now. So Lordship, the son will offer Lordship something, Lordship. So far as my information that the petitioner is not, even the respondent, so far as my information is not in a very good healthy condition, Lordship now.
You see, even the estate would be bound. That house which you will be offering will bind both the estate of both the persons. At this age of 76, if he is still homeless, or staying at the charity of someone else, it would not be appropriate. This order has to be executed. Where is the date?
Lordship, can it be on
10th of June?
18th or 19th, Lordship?
That is too
Sorry,
long.
Sorry, Lordship.
Make it 10th or 12th of June.
Lordship, 12th.
What about my lord, in the year 2018, this GLP has been filed. Since then, my lord, as on date, no such offer has been made by them. So for the offer, what they want to my lord give, my lord, that will be my lord specific from.
Yes, I'll get the specific.
That's what we are asking.
That may be reflected in the mood of communication.
the fundamental unless counsel for the appellant waits for some time to come with instructions as to what sort of accommodation would be offered to the respondent. So it is submitted that as per the petition filed on 19/2018 before the learned family court in connection with the execution case being FC within bracket P to stop EH to stop bracket close P of the 2016. The car keys were already handed over to the respondent and a room in the compound of the petitioner was ready to be handed over. Most of it is submitted that by passage of time, the said room is not in a good condition, correct?
Yes, sir.
Not in a good condition, and therefore he wants to obtain instructions as to what alternative accommodation can be provided to the respondent in terms of the judgment and decree dated 8/1/2014, passed in FC Civil 151 of 2008 by the Court of Principal Judge, Family Court, Gauhati. Next panel. Court takes notice of the fact that on around 24/5/2018, when this application was filed, the petitioner was 79 years of age. Of the Mr. N.K. Sharma, learned counsel for the respondent, has submitted that as per his instructions, the respondent is now 76 years of age. This one.
76 years.
That is under the circumstances, having noted that the execution proceedings being FC Civil, FC in the bracket TX, P of 2015 is still pending. Or the petitioner is put to notice that in the event definite statements is not made with regard to the nature of accommodation to be provided to the respondent, the matter would be heard on merit without any adjournment on the next date of the case. Next, this promise. Here, 12th of June.
But, all right.
Guys,
Bye.
For orders, division bench item 1, 2, and 3.
But if I have received some instructions, I have placed this notification within this one. And the social audit reports kind of two copies or two sets have been given for the court. We have already served the copy to the other side. And two sets we have handed over to the school.
But this should be, rules are not notified.
No, the rules have not been notified.
That have to issue a judicial order that till this it is notified. The central rules. That have to be right. Because any of our queries or orders. See, number one, you say that we have sent to the registry the letter dated 29/4/2026, last page of this compilation. Now it says that it will be in compliance with the High Court's order dated 22/4/2026.
2/4/26.
Yes, 2/4/2026.
Yes,
So you have just submitted that. But the, we wanted you to address as to the number of cases pendency and then the,
that list was already on earlier occasion we have handed over. It was given, right?
Number of pending and the
Yes, from the clock.
you have a copy of the chart.
Five years.
Well, the last inspection,
This one is like,
30th of March, yes, 30th of March. In that instruction, kindly go to page number 6, no?
23rd March.
30th of March. Our letter is 30/3/2026. In that branch, kindly see page 6.
30th of May. 30th of May.
30th of 30th of May is the instruction today I have given.
Yes. 30 March. Last, we will locate.
30th of March, the communication I have, but it doesn't contain any list of. No, Lordship, I'll take your lordship. There is a list here. I'll take.
One list we submitted and another list is submitted, Milo.
Is available.
Two lists were there on the previous occasion.
If that is available,
Yes.
one was the report of, Ashade Kumar.
One under the heading pendency of cases in juvenile justice boards in Assam and another is case disposal ratio in the juvenile justice boards in Assam.
That is
Just a moment. We will
that
first
is
pass
given in
orders in that item number 3. That is that, particular, that rule. They will come to this.
Take from, no, this.
No, no, we cannot know.
Here is the econ committee. Take from media.
They can't tell the rest of them.
Media. Valid to decision media, but this, improvement will be valid to come. Take from decision.
Then government.
Government. Can we have the savings account? So, econ decision will become there. No? So, econ decision mechanism. Who says? Parallel with this person actually. Yes, yes. So, last. That's what I see. But in fact, it was placed, you know, as I have placed before your lordship, it was placed, but with some query. Malad, with some query, Malad, it has been given.
Mr. Nath, Mr. Nath, it is very simple. I can ask you a question and then adjourn the matter. Second day, I will again ask you a question and then adjourn the matter. Is that a solution?
No,
If at the secretary level, they don't have a meeting, they only put queries here and there for response.
Instruction to any vision. You can do the pages that no names before that. Football class will be done. But they are doing. They are doing. In mind, this is what question is to say. Okay.
That's so good. Can you give us, idea for you? How many days you have dealt with all these issues?
Yes, Millet.
What are their grounds and of delaying it?
Millet, first two paragraphs of the today's instruction is like maze, Millet. It's a football match going on between the departments.
No, you see, the problem with us is that we really don't have time to look at into the all previous orders and to find out.
We'll assist, Millet.
On
We'll
which
assist.
date we first pass an order for the notification of the rules. And then what my esteemed brother is asking is that the various reasons assigned. That, and at the end, we are here today where nothing is moving. Is that
By
instruction?
tomorrow, we can give, by tomorrow, we can give, madam, no problem. Yes, madam. Lord, we'll get the order sheet online, madam. Order sheet to online আছে, ওগুলো honorable court said 4 days nothing the order, we are communicating, we are also accepting. Logic, logic, logic. Malakum. That's all. At the. Yes, sir. Yes. Fine, madam. Fine. By tomorrow, I'll. Madam. Logic में direct case supervision मतलब in the matter, and if not, logic में pass the order मतलब. Even मतलब.
In the meantime, you have an instruction.
Logic.
When these queries can be computed and this method can be traced, the appropriate level and before the appropriate authority, so that you feel the right of the.
That is the ultimate from last many days मतलब it is this is in the. Next year, reading of these two paragraphs, first two paragraphs of today's instruction, you know, some queries.
Election otherwise, my lord, was of the year 2018. Other Supreme Court.
Proceed. We thought we will be hitting the country that will have the real charges. You are to focus that.
Now, after preparation of the draft, the process is slowed down. The draft they have placed.
Can be addressed. If the state does not want to work, we cannot compel them.
No, I'll not say that, I'll put it otherwise,
Yeah.
they are working, but they are working, but very slow. Not.
That's all.
The pace in which they are going is very slow, that's true.
Feedback make some queries, huh? Women and Development Department replies the query. Then Home Department everything. Nine, the whole line. Then draft policy. Draft policy, Judicial Department, School Education Department for views. Clarification, upon clarification. Same has been addressed, sent back to our Judicial Department, School. E office of Demo. E office of policy. This is making department of the university for it also some involvement of family. This is item number 3. We have 16. That's okay. It's not from the something. Instructions dated 30/5/2026 produced by the learned senior government advocate. It is seen that though the court is though it is in the notice of the court that the
rules that the Juvenile Justice Care and Protection Act is not been made by the state of Assam, for which various orders have been passed from time to time. The state is still in consultative process. So therefore, as there is absolutely no progress seen in the implementation of the notification of the rules. We request the Mr. H. K. Das, Senior Counsel, and the Standing Counsel for this board to assist the court in giving list of dates on which various orders were passed from time to time. Directly the state to take under steps for notification of the rules under the Juvenile Justice Care and Protection Act. As well as the reasons of delay which has been explained by the state, which is recorded in the various orders. So you can also assist to the last. We request Mr. N. Public and Magnus to also assist us. The Standing Counsel in the if required, or the courtmaster shall hand over the order sheet to the Standing Counsel for this court to the next one. The Standing Counsel for this court based on delays time. Accordingly, this is on 4/6/2020. This matter is segregated kindly. Now,
Yes. No. On day after tomorrow. Not. Yes, yes, absolutely.
because
Yes.
but the first call will come from the State Child Protection Society.
Yes,
Then second would be the Department of Women and Child Development.
yes,
So in the meantime, you can speak to the authorities, both the authorities of Child Protection Society and the Department of Women and Child Development. So what is their idea of
as,
how
as,
to follow it up?
as regard the recommendations. Lots of, yes.
So probably the question is that whether the state has accepted this report.
Now, this report, they have not a social audit report they have given us, and it is today before placed before the honorable court. And ultimately,
So this report you see is not to the court. It's a social audit report which is submitted to the Child Protection Society and the Department of Women and Child.
yes, sir.
So they will have to first,
Accept the report.
because they are accepting a report.
Then we deliver it. So then we may require whatever your suggestion what is the compliance that is required?
Correct.
How the accepted, then we can deliver. It cannot go detail.
Yes, sir. Yes, sir.
That you have
What is-
my.
Yes.
Yes, sir. We have given the copy. What is their roadmap? What is the
That task that should not have so much of time to read.
No, we'll have time, my lord. We'll have to.
No.
It's our
The
responsibility,
road-
not that.
the next,
This
next
requires
course of
some
action?
expertise also.
Correct, my lord.
We are not doubting your ability,
Correct, my lord.
but if it is for the implementation of the child and this child welfare, then some experts who are dealing with the matter,
Correct, my lord.
they will know more.
Yes.
That's paid by their concerned department. Will be the implementing authority of this. service.
Exactly.
They must have their own idea, they see before us, that these are the solutions.
What is
We are proceeding in this direction to fill up this gap, what correct this. problem.
Correct assistance from the department may, my lord, give a different picture to the recommendations, my lord. Because they are also the expertise.
Cannot be, but tell them on this. Then we
That's
will
true, that's
come
true,
back with
that's true.
executing order,
That's
Yes,
which we are not.
yes. Possibly
the
correct.
course of action, what they are adopting, that will apply.
We may suggest something, we might have to.
Lots of.
But we can do it after it. Yeah, right.
After the course of action, they have proposed. True,
This
true.
the Department of Women and Child Development,
Ma'am.
we are expecting that they will have expertise, personnel with them.
Yes, ma'am.
Those who are aware of what is there.
Ma'am.
This,
This kind of connection.
Yes.
They say, what is the result of the audit? Always after audit, there will be some recommendations, they will say, there is a, without this, then it gives, give us a start and we highlighted issues, that we are proposing to tackle these issues. Then only we can clear it.
Correct.
This is basically a ground level report. Ground level report
but
of
this,
the entire.
this portrays a picture that the roses are neither red nor pink.
Yes.
But the shelter homes,
But this, there are not.
Well, definitely, madam, I'll apply. I'll apply. I have, absolutely, well, we are not taking to the same. Correct. Correct. We have already communicated the displeasure of the honorable court and the delay, because of the delay, I'll definitely apply, sir. At times, you know, it is difficult for us also, you know,
That's why we can conflict.
absolutely,
All the. Absolutely. I can officer to.
absolutely, absolutely.
we request the officers, suggest the name of a particular authority. We request them to give video conferencing on the night control.
It can be done, it can be done. I.
All therefore have that idea.
On
That we can.
logic. Logic. Or.
R.H. Chaudhary, MS R.H. Chaudhary, on the last occasion, she produced one chart, you know, seeing where there is, the shelter homes are there or not, district wise, you know.
there in the file, I think.
Yes.
So it shows
South
that.
Salmara, there is no observation home, no shelter home,
No,
no temporary home.
yes.
West Karbi Anglong,
What the response, this one is the order. If not.
West Karbi Anglong, no.
No.
Divasao, no. Sirsagar, no. Yamaji, no. Tibumi, no. Nalbari, no. Solipur, no. Karbi Anglong, no. Kalpuri, no. Temporary home, no. Propeta, no. Friday, no. Vishwanath, no. Praja, no. Iran, Hubli, observation zone is not there. Nova also. Definitely no. Brought on no observation.
My lord, we'll also have a look at the order dated 2/4/2026, my lord.
The state is to submit a proposal.
Yes, pursuant to this.
And he has come.
But here, in fact, Mulad, we have waited for the report, the social audit report, because the report is going to tell the observation homes and everything, the status of observation home, where it is there. Altogether,
First of all, the Mrs. R. Chaudhary has given us a license.
yes, no,
You don't deny the correctness of this.
no.
Then therefore in the order of 2/4, we say that in light of the chart, state shall submit a proposal for compliance of the provisions of Vienna Justice Act. But if you don't do,
No, in fact, on that day, it was,
Now the question is, these are existing, but under improvement is required. That is the qualification. And here are the two, during
no observation home. True.
we are acquiring legal sector of then it may be a ground for not having shelter.
A separate thing.
How we are
But one of that is, but in fact, in the recommendation thing, I have seen something, and Lordship, another two aspects were there in this report. Here, one of it was also pointed out that some juveniles were in the jail, and what happened to them? There is an affidavit has been filed by them taking care of that situation. That has been taken care of.
But it will be, my lord, you have now you shifted to adult, from adult to juvenile justice. In Pakistan, we are what we call a juvenile justice board, and if you fix it, there are now. So the situation is resolved.
That issue has been resolved. So for the other, where the no observation home is there, that instruction, we need some time. What they are going to do or what steps they are taking.
বস্তুটো চাবি এই চাউথ চালমাৰৰ manufacturer
See, they think, just say, what happens if the court finds that any law which is in pursuit, forget about this JJ Act, XYZ, any act, if that is not complied with the state, what are the recourse that can be taken by the court? Supposing the act is a particular thing to be provided, it's not provided. What do you think the court would have power? They issue mandamus. So therefore, instead of the court issuing annuals, we are giving you an opportunity to come up with a proposal. That was there in the order, there is 2/4/2026. Nesting was already told you, we know how to implement it. But if it comes from the orders of the court, if it comes from, you know, that this is how we are processing, that means we are actually giving you more time than what is required for the implementation of the act. So when it comes from the order of the court, then we will be doing it in a time bound manner.
In fact, Lord, in earlier orders, I'll point it out to the honorable court. Earlier orders, it was placed before the honorable court that these are the numbers of the government run and the private observation homes are there. Orders are there, and we have also stated in that, my lord, that the observation homes, if in some district it is not there, ultimately observation home of a particular district is catering the need of 2-3 districts are there. Those instructions already there, my lord. It is placed before your lordship. Now we are required to apprise the honorable court that where it is not available, what steps they are going to have a new or new. Yes. Yes. As regard setting up of new, my lord, I prefer some time. Otherwise, that has been taken care of. That if there is a juvenile in South Kalmara,
Okay, you have given that before, but we have got nothing on record to show that it has been notified by the state.
my lord, I'll place it. It was observed. It was on record, my lord, it was placed and lordship is okay.
No, that is there. This is available. But you see, what you say that there is a temporary shelter home and you are doing it in band.
No, my lord, in fact, in Assam, there is no temporary shelter home. On affidavit, we have said.
No, it's suppose in Gauhati.
But those are not constituted by government. No temporary shelter home is constituted by the government. After eviction, at some place, the people go and stay out of their own will.
You're correct. There may not be any shelter, private state, or a home, but there may be some private kind of thing which we recognize to enjoyment.
Yes.
In fixed a single situation, based on the report given by producer.
Facts and figures, lordship, it is placed, I will indicate, my lord, I will indicate, it is observed by lordship. Lordship. Yes, it is.
For what of shelter very things like that, kept in restriction,
No juvenile, lordship.
that situation may arise, as of now.
Yes.
This is the actual position
Ma'am.
based on that basis.
Doctor.
That we have created in our earlier organization.
But please for a moment, lordship kindly takes up order dated 25/6/2024. In PIL 60 of 2019, not in this flight, not in this PIL, lordship. There, on 25/6/2024, madam, pursuant to lordship's order, we have placed it before the honorable court that
We have that. We have that.
What?
You see, here you say that, for example, shelter home
now,
is running on a granting aid basis by so and so.
No.
That means you have a policy for a shelter home, that is why you are giving. The reasons why Workers still always saying that they are restricting from whatever reasons is being effectively used or not used. You have to give a short affidavit.
Not-
record.
not. In this, that is why, my lord, I indicated that. Twofold. I'll do. Not, that is why, my lord, I have indicated that report, because the report indicates that how many observations homes are there, you know. Not, so this is the. Yes. Yes, yes. So what is the situation and what is the area those institutions are covering? That is no. That's I'll indicate. I'll indicate.
I think you go. Here you go.
So for the immediate requirements of shifting the juveniles, madam, that has been taken care of. Rest will happen. Rest will happen. Super.
He now connects government application. Is referred to order dated 2/4/2026 and since for some time to submit the proposal as indicated there. So we submitted that. In the meantime, in respect of the districts of Gauhati, Bihar, and Tinsukia, where were kept in the jail. So my understanding is that the issue has been resolved. As the penalty for the federal judge in Jorhat, what has happened?
They were in jail. They have been shifted to the home.
But they've been shifted to Jorhat. And
But in their affidavit, they have said. As on date, there is no doubtful juvenile.
They have been brought with the court, and they were brought before the juvenile court, but where they are staying.
Well, as on today, ultimately they have said that no doubtful juvenile is in jail.
Just the fourth part happened, fourth part is the legal. We have to birth certificate, we have and the court, the image was the adult. Therefore, the juveniles are having got under the juvenile district court, not to the adult.
No.
And what about the Tinsukia? No.
Okay.
Recorded in the order. Thank you, that's the other side. Thank you so much. Mostly after vacation, this matter. Mala. And the other matters which you are taking out there, tomorrow will be merged with the same day.
Lot. Yes, sir.
First, limit billing. 21st July.
21st July. 21st, lot. Pending. So pending.
They are also reviewing this, the dates.
Yes, lot. I'll give the details.
Same day. And then item number 3. Sorry, 2.
Two and three are connected. 2 and 3 are connected.
2 and 3 is connected.
2 and 3 are
I mean,
connected.
I can see you say.
Yes, 2 and 3.
Previous order.
On fourth. 2 and 3 on fourth. On fourth. Two is relating to the Bachpan Bachao Andolan. This is the case. Lordship has taken so many.
There is no matter, but.
Two.
I have two so.
I can two so many.
Three Bachpan Bachao.
2 and 3, they have to.
2 and 3 thereafter.
They got presence of all the content class. This instructions you have given is in PL 16.
Yes, Lord. PL 60, which is 2 and 3, are connected.
But please tell them this particular thing has been continuing for too long. This issue of rules.
Correct. Correct.
Almost 1 year.
More than a
Yes.
Almost 2 years. Yes, sorry.
plus.
Yes.
After lawsuit's order, at least the draft came. Now the notification part is taking up long time. No.
In fact, your lordships never took this to be an adversarial litigation.
No,
Never.
So that part. In order to make the officers comfortable, we say that you don't come. We omitted the affidavits. They are not taking the code very lightly.
No, look, yeah. In fact, the officer concerned who is very tricky, he got transferred. That is one of the factors. 2 of the officers were.
Item 4 for orders.
Deeply open. Make the petition is filed by the petitioner against the order passed by your chief. In WPC number 233. Yes, my lord. Order. It's page 61, my lord. Operative part, my lord, will be 66 last, 13, my lord.
What is incorrect in the order?
66 page, 13, my lord.
Page?
66, my lord, 13 para. Therefore, in the light of the discussion above, the court does not find that the my lord, actually, my lord, there is some. I have collected some new document, my lord. There is no, frankly speaking, my lord, there is no such error, my lord. But my lord, my grandfather is a citizen of India since 1961, my lord. Document is here, my lord. So my only problem is I could not appear before the learned trial court below, my lord, or tribunal below, my lord, in time, my lord. That is why expert order was passed, my lord.
Where is that order of proceeding ex parte against you?
Please, 35, my lord.
35.
Yes, my lord. My lord. 36 para 2, my lord. There is in details, my lord. Self-adjournment was given, my lord, by the learned tribunal below, my lord.
You give a notice, but fix it after the vacation. Correct? In the meantime, you address us. Then we don't have to want to disappoint Mr. Das. And Mr. P.P. Das, then counsel for the petitioner and so on for the respondents. Issue notice of this new petition, returnable on 15/7/2026. So extra copies, requisite extra copies of the new petition be provided to the government. CGC State Department Council of the 2 days. This comes with.
Item number 2 and 3. Look, if you kindly note that the audit report has been given to the court.
Past order, I think, this is the social order in 3 volumes.
In 3 volumes.
Depend by the senior government.